I'm Dr. Purnima Gauri. I'm a neurologist and a social engineer. I'm based in Pune and Nagpur. Today is World NGO Day, and on that occasion, we have organized this program of Law and NGO. My social engineering, for instance, happens through my activities, our activities of our NGO. And Niche Advocacy Foundation is our specific NGO which is working in the field of mental health and emotional fitness. Niche, as you just saw on our website, stands for neuroplasticity for individual and community health education. Neuroplasticity is the amazing ability of our brain to learn and change. So, as a neurologist, I felt that the principles of neuroscience could be applied in day to day life and we could be better people, we could grow better with the understanding of neuroplasticity. During lockdown, our work increased as we reached out with our online programs. Our activities became much more regular, actually, and our online internship program also started on 7th May 2020. Currently, our third batch of online interns is going on. As our work increased in the online world, we realized the loopholes and the pitfalls in the legalities of running the NGO. For instance, just now, those of you joined on time, you saw that two of our interns were giving their experiences, they were sharing their experiences. Now, this simple video, putting this up on our website itself, has a lot of legal background behind it. We need to take the consent of both the interns. They have to be willing to share their personal presence on the social media on our behalf. So this also is a legal aspect. So as we started working more and more, we started realizing that there are a lot of issues that we face or we can face which are legal in nature. So we realize that there are some aspects we are aware of and some aspects that we are not aware of, and we realize that we must learn much more. And we found out that law and NGO is not a very refined field as yet. Like corporate law, everybody knows. Criminal law, there are very specific roles and regulations around it. Now, all over the world, we thought that there are so many NGOs working towards the betterment of life and society, and each NGO's nature of work is different. हर NGO का society में जो contribution है वो भी अलग है. It is essential to know the legal aspects of running an organization, especially a non-government social profit organization. Very often we know the rights, but we are unaware of our responsibilities, and sometimes we are even unaware of our rights. So that's why this project we have taken up, and we thought that World NGO Day would be the best occasion for when to execute this project. So we are very grateful to our three speakers today who are from three different cities. We have pre-recorded their talks, and in addition, Advocate Talekar and Advocate Agarwal will be available for live question and answers at the end of the three talks. So they will be coming to our meeting when our live question and answers start. Now, I request Ishan Gorulkar, who is our intern and our third year law student from National Law University, Mumbai, to introduce our first speaker, Advocate Pradnya Talekar, who will be speaking on the basics of formation of NGOs and rights of NGOs. Over to you, Ishan.
Thank you, ma'am. Good evening, everyone. I'm Ishan Gorulkar, and I will be introducing to you our first speaker for the program, who is Advocate Talekar. Pradnya Talekar, ma'am, is a graduate of law from National Law University, Jodhpur, with honors degree in intellectual property right, as well as a distinction holder in her PG course from University of Oxford. In less than 6 years at the bar, ma'am has conducted diverse variety of matters concerning constitutional law, taxation law, property and civil rights, commercial and corporate laws, as well as criminal law. She has nearly 50 reported judgments in her credit. Pradnya ma'am, at a young age, has appeared successfully in high-stake matters, also argued complex constitutional issues. She has appeared against one of the country's finest lawyers, which include Mukul Rohatgi, Kapil Sibbal, Mihir Desai, Shri Haryane, and several others. Ma'am also chairs the Confederation of Indian Industries, Indian Women Network chapter at Aurangabad, which works to provide peer network and support group for professional women. We are glad to have such an inspiring personality with us today for this program. Welcome you, ma'am.
Thank you all for coordinating this event. It's a very interesting topic, and it's my pleasure to be addressing everyone on this. A gathering of NGOs is really something that we don't see as often, but it's really, really important as I see it. And talking about laws and NGO, there are really two aspects to this topic. One is the laws that would govern a non-governmental organization and the compliances that are required for the NGO to follow. And the other is how an NGO could have an impact on the law of the society. Uh, to my mind, the first is more of compliance oriented, just knowing the basic rules and regulations and then following it. So I'll deal with that in a shorter part towards the end of the talk. But I want to focus the talk on how NGOs and all the players working in this sector can have an impact on the law. Roscoe Pound had propounded the theory of law being a means of social engineering, which really means that law could be used as a tool to bring changes in the society. And when you talk about law, it's not just something that the legislators would formulate in the parliament or the legislations, but also the judiciary. And public interest litigation is this means where we go much beyond the technicalities of law towards justice. So what we used to call as Niti and Nyay, the difference between the two. Niti, which really looks at the regulations and the institutions, and Nyay is applying these to bring about justice. So public interest litigations are a way to bridge these two. And for the larger society, which may be suffering through some evils and may not be able to voice their own concerns, anybody else can pick this issue and go to any court, even if it doesn't have jurisdiction, a high court, of course, a high court or a Supreme Court, any constitutional court, and say that such and such issue is there which requires indulgence of the court. The court can examine the issue, and if it finds that there are bona fides and there's no personal interest involved, or it is not merely by way of a publicity stunt or a means of extortion, then the court can entertain this petition and can also give directions, which could be in myriad kinds. So how can NGOs work towards filing public interest litigations or bringing about a change in the law? I feel that the word NGO, non-governmental organization, actually doesn't do justice with the kind of work that we see NGOs doing in India and actually world over today. They're doing such immense work in different fields, be it education, be it prisoner rights, be it environment, be it feminist rights, be it like the present Niche Foundation, which works on patients and psychological issues, neuroplasticity. So there are immense areas in which NGOs, think tanks are working today. And since they work on field and have a lot of experience working on ground, they know the problems that exist. So they really know the right questions to ask to the government agencies or to anybody who's in charge, maybe a semi-government corporation or institutions which are aided by the government or funded by the government. And if you ask the right kind of questions, you can call for documents. You can do a data gathering mechanism. Once you have the data with you, you can utilize this data either to file litigations in the High Court. Personally, as in being party in person, you do not even need to engage an advocate. If you're really interested in a cause and if you want to advocate the cause, and if you have all the data and the expertise in that area through your on-field experience, you can put together a brief and you can go to the court. There's a certain procedure that is to be followed before the registrar of the High Court or the Supreme Court, in which they would just see your basic level of understanding of the issue and whether you will be respectful towards the court and your arguments. And if they feel you will be able to do that, then you're permitted to argue the matter in person. You do not need to engage an advocate. If you feel you do not have the time or the resources to resources to do this personally, you can always engage advocates. There are a lot of advocates who would work pro bono on issues which really seem genuine and for bona fide purposes. Public interest litigations can range from several areas and fields. Most of them, as gets the media attention, seems to be whistleblower kind of PILs, which are either blowing out scams of corruption or work not being done properly, unethical conduct, immoral behavior, trafficking, etc. But these are not the only kind of PILs. There are several other PILs. Say, for instance, the MC Mehta line of cases, which are on environmental laws, wherein, the Taj Trapezium case or the cleaning of Ganges, having right to free air, filling in the potholes in the roads. So all of these cases, which are not really targeted towards a particular individual or a set of individuals who are found to be corrupt or in any manner conducting notorious activities, but towards developmental activities or protection of fundamental and human rights. This would also range towards beyond environment, education, child labor, trafficking, patient rights. So there are several issues even in developmental activities. Apart from this, there's a third issue about institutional and welfare state building, where also you've been seeing a lot of fresh growth of public interest litigations. Some of the examples are, say, the Shirdi Samsthan range of public interest litigations at the High Court of Bombay bench at Aurangabad, wherein literally for a period of 4 years from 2011 to 16, and thereafter again from 2019 onwards, the Samsthan policy decisions are confirmed by the High Court, and every single thing, where to bring the ghee from, where, what kind of flowers to get, how much do you pay for diaries to be published in the Samsthan, all of this is scrutinized by the High Court to ensure that the right kind of activities, developmental activities take place. And it's a queer circumstance because the government failed in its obligations under the law to have a body of trust on the Shirdi Samsthan in the manner that is required in the law. So having developmental activities being overseen directly by the constitutional courts, say the High Court or the Supreme Court, is not a general phenomenon. But in certain circumstances, if we can show that the government is failing in its obligations, then the High Court can take this up. So these are the three broad areas in which the non-governmental organizations can definitely come up, file applications under the RTI Act. The 2005 Act is a brilliant act. It's a very, very user-focused act, since it gives a 30-day timeline. And all you need is one stamp and a sign on an application with details of what you want from any government department. And it will be provided to you within 30 days. If it is not given to you, you can go in appeal, which is again put under a time limit of 30 days. So once all these documents and data is available, and it's much easier, like I mentioned earlier, for NGOs to take this up because they already know what's happening. You only need a confirmation from the data and the documents from the government. But since you're already working in the field, you have an idea of where things are going wrong or how they can be made better. So I really hope we see a lot of NGOs working in this field, and coming together, we can make an impact in bringing some changes to the law for the better. Now dealing with the laws and compliances that are required for any NGO to fulfill. First, what is an NGO? Does it have a legal status? So NGO itself has no legal status as an entity. It could either be a society, it could be a trust, or a company. If it is a society, it is governed by the Societies Registration Act 1860. If it is a trust, then it has to be registered and is governed under the Public Trusts Act 1960. And if it is a company, then it is governed by the Companies Act. And an NGO has a separate entity status even under the Companies Act. It is not a private limited company or a public limited company. It's a company under Section 8 of the Act. And mostly the filing of returns or filing of accounts, etc., is the same as any other company. Even the number of directors, etc., is similar. But there's a different section that is outlined specially for non-governmental organizations under the Companies Act. As far as the Income Tax Act is concerned, there are some benefits that are possible to organizations which are committed to doing non-profit work. The first advantage is under 12A, Section 12A, which deals with no tax on the income that can be accrued to this organization. There has to be a registration under Section 12A. It is not mandatory, but if you want to be entitled for the benefits under the Income Tax Act, then you must register. You will not get the benefits without registration. The second benefit that is possible under the Income Tax Act is to your donors, whoever is donating the money or giving any funds as charity. That person could get benefit under his income tax returns if an ATG certificate, Section 80, subclause G. So if an ATG certificate or registration is done by the NGO or the non-profit, then the donors will also have an additional incentive to be fundraisers for your cause. Apart from this, depending on what kind of services you might be using, you may be liable for having a GST certification, a Shop and Establishment Act certification, a TAN if you do not deduct the TDS tax at source at some time. So these are some compliances that you must ensure they are followed by speaking to a tax advisor or a chartered accountant. Apart from this, something that I think is important to understand, not in terms of technical sections, but as a concept. Once you have a non-profit organization, the most important thing is what is the relation of the people who are running it with the funds or the properties that would be held by this organization, either as a society, a trust, or as a company. So none of the directors or the trustees are allowed to get a profit or an income from the properties or from the workings of this NGO or non-profit organization. It may be arguable that if you're registered only as a society, not as a trust or a company, then you may bring a part of the income of this society which claims to work as an NGO towards the personal income of the people who are running it. However, then the question of taxability of that income would come up. If it is not an entirely non-profit money, then it would be open to taxation and you may not get the benefit under 12A of the Income Tax Act. So far as the trust and the company are concerned, however, there is no possibility under the law to even draw a penny to the directors or the trustees from the NGO. Similarly, for the property, everybody who is running the show only acts in fiduciary capacity so far as the properties are concerned. You may be allowed to even sell, assign, put a lease on the property, but for the interest and for the benefit of the cause that the trust or the society or the company is attempting to achieve. What about dissolution? Now, under the Societies Registration Act or even the Public Trust Act, there is no dissolution of the entity. So if it becomes non-functional after a period of time because people are not taking interest, then the charity commissioner may, through using his powers, appoint or nominate different trustees and hand over the work to somebody else. But there is no dissolution that is possible under the Public Trust Act. So these are some of the things that need to be borne in mind. Of course, an NGO at the beginning, for its establishment, for its working, I would always recommend that proper legal advice and proper accounting advice is taken so that no mistakes happen, because there will be consequences. For instance, the FCRA is another important act that needs to be looked at. Is the foreign funds contribution is controlled through this act, and you need a license, which is a mandatory license under this act, for you to be able to collect funds from other countries. Say somebody in the US wants to contribute to your cause. By matter of course, he cannot come and donate some money. If he has to wire transfer the money from the US, because there is some change in how the funds from dollars are converted into Indian rupees, and there's a liability on the country of how much conversion is possible on a daily basis. So to take care of all of this, there's a specific statute which is called the FCRA Act, and it requires NGOs or even individuals who are working for a certain cause to register and have a certification under this act. And it needs to be, you have to file returns every year, you have to show utility certificates, and if these are not done, then even your bank accounts can be frozen. So there are some consequences of not complying with the laws and regulations. uh, so you can have a brief idea by listening to talks or reading up online, but before you actually start an NGO, or if you want to ensure that it's working well, I would always recommend that proper advice is taken. So I hope this is of some help. Thank you.
That was a very basic, it was a talk covering most of the basics. And thank you so much, to my heartfelt thanks to Advocate Pradnya Talekar for having addressed this basic topic.